One of the ways reporters collect quite a bit of information in order to report to the public comes from their coverage of government meetings and government sessions and their access to records that are kept as government conducts the people's business. And the access to those records is where a lot of information comes out, but it's also a place where governments and the media can have some conflict when it comes to what is okay to release and what's not. So let's take a look at that. Now, the Sunshine Act is actually the Federal Open Meetings Law, which was passed in 1976, and it basically applies to a multitude of federal agencies and boards, saying that these meetings will be open to the public, they will be open for press coverage, there will be minutes of these meetings kept. It's basically the idea of this check and balance on the government system. These open meeting laws ensure that we will, as the press and the public, have the access that we need to know what goes on at these meetings. Now, 43 states also have separate laws related to having open meetings and open records. In Ohio, it's called the Sunshine Law, and you can actually access it off our blog, our class blog, at the NicoleCraftOSU.wordpress.com. It's called the Yellow Book, and we certainly discussed a decent amount of it when we were talking about our Supreme Court case looking at the Columbus Dispatch and its desire to get access to Columbus City schools. So all of that case, the background of it revolved around this idea of the state open meeting laws. Now, as we know from that case, there are exemptions to having open meetings, one being executive session, where we deal with legal issues and personnel issues. So you can start to see how that law is applied and how certain government bodies will at certain times look for ways to close meetings based on the options that are provided within that law. So we're relying a lot on these open record laws to provide us with access to the business that the government conducts on our behalf. That being said, there are limitations to them. Now, the Ohio Open Records Law, for example, was passed, and it said that all of the records that are done in conducting the people's business are open, except the ones that are deemed that they shouldn't be open. And so that's enabled various legislative bodies and the courts to close certain aspects of these open meetings, and certainly there have been more than 100 restrictions that have been put onto the open meetings law as it exists in the state of Ohio. Now, some observations of a lot of these open record laws as they relate to the state. Basically, the state is not required to create or acquire any records for you. So if the record exists and you request it, a lot of times you have access to that, but it doesn't have to be created for you. It's covering all three branches, the legislature, the executive branch, and the courts. There are some restrictions that the requester has to be a state resident. We do have the option for covering the electronic and computer stored records. Those are also included. But there isn't really a response time reflected in these open record laws. And truth be told, there's not a great deal of penalty for agencies that don't comply with this law. So we really have two different aspects that we have to look at when it comes to open records. One, the state laws, the sunshine laws that we have that give us access to state records. And then we have the federal records that we would seek from the federal government, and they actually fall under what we would call the Freedom of Information Act. That was passed in 1966, and its goal is that it requires all of the records that are held by the federal government to be made available to the public. And what the court has supported in terms of this legislation is that disclosure, not secrecy, is the dominant objective of the act. So its goal is to make government more transparent. Now, before we had FOIA, prior to its passage in 1966, the burden was basically on the requester of information to say, I have a right to examine these government records and I'll prove to you why. But there wasn't really any guidelines or procedures in place to help you if you were seeking the information. And there wasn't any judicial review available to you if you were not provided any access to these materials. After FOIA, the burden of proof shifted from the individual onto the government. And if you think about it, basically, you've heard that term, need to know. Now it's considered that we basically have a right to know the information and the materials that are gathered as government conducts the people's business. So Basically, this gives you a right to request information. Now, it's not absolute. It's not guaranteed that you're going to be provided everything that you want, but you do have a right to request them, and you have a right to receive a response to your request. And if the record can't be released, then you're going to be told that it can't be released and why that is the case, and you have a right now to appeal that judgment. So here's some of the basics around FOIA. One, it applies to all federal agencies that exist at the executive level. That means, however, that it doesn't apply to Congress or the federal courts. It doesn't apply to the military during wartime or military court-martials. The goal for FOIA is that it requires these federal agencies to publish a description of the organization, a list of people to be contacted. It also requires that they publish the procedure by which records can be obtained, and that those records have to be segregated so that a whole record can't be considered classified as exempt, only parts. So let's take a look, just for example. Here, if we paste in the information related to the FBI's FOIA request, this is what comes up. So it shows you FBI records, Freedom of Information / Privacy Act, and it shows you exactly what information you need to give the FBI, who you can contact, where you can get information to contact them, and what records are available by request. So this is pretty much a standard page that you'll see on a lot of government agencies on how you would file a FOIA request of this particular agency. Now, some of the details that you need to know is we have to define what is an agency. So it would be an executive and military department, government-controlled corporation, executive branch, including the executive office of the president or an independent agency. Now, what a record is isn't exactly defined by FOIA, so that's open to interpretation. We kind of look at some fixed terms like it's a document of government in action, something that can be reproduced. It also, based on FOIA, has to be something that already exists. You can't require one of these departments to create a record for you that hasn't already been compiled. So we amended the Freedom of Information Act to include electronic records in 1996. So that said that records that are subject to FOIA will be available when they're maintained in electronic format. You can receive them in electronic format. It says that requesters can seek the data in any format in which the agency maintains those records, and that the agency will make a reasonable effort to comply. It also says that agencies that are redacting electronic records, which is when you delete a portion of the record in order to prevent the disclosure of material that's not covered or that has an exemption, they have to note the location and the extent of any deletion. And then there's an expedited process for electronic records. So basically, requesters, we need to be looking at this in a fairly timely manner. Some more amendments that have been placed on FOIA, the idea of multi-track processing. So these agencies can establish this procedure for processing requests in a variety of different sizes, that larger numbers for larger requests and smaller numbers for smaller requests. So that means that the bigger your request, the longer it may take for them to comply with that. And what the goal is here is that you, as a requester, you will narrow down the frame of what you're looking for and not ask for big giant chunks of information. There's also a deadline now, so the deadline for responding to a FOIA request was extended to 20 days from 10 days. So the government agency has 20 days to respond to you. So to make a request, it's fairly simple. It has to be addressed to a specific agency, and you can locate the office appropriate for your request. And you can actually find that right here in a really handy document that I encourage everybody to check out. It's called the United States Government Manual. Let's take a look at it. So this outlines for you, it's basically your handbook for the federal government. It provides you information about all of the different offices that are available. As you can see over here, we have the Constitution, the Declaration of Independence. You can look at the government's organizational chart, different boards and commissions. It gives you basically all the contact information that you'll need for contacting the government. So FOIA requests have to be in writing. The goal is they're very short and simple. It may seem like a very formal process to file a FOIA request. It's really not. You're basically saying that under the Freedom of Information Act, you're making this request. This is specifically what information that you're looking for. You have to be very tailored in your request, and you have to make a very finite amount of information that you're requesting. You can't just say you want all of the records related to a specific office or a specific time. You are often restricted in date requests and a specific type of record that you may be seeking. You address it to the agency's FOIA officer, the head of the agency, and on the envelope you put Freedom of Information Act request. Make sure that you say that it's being made, this request is under the Freedom of Information Act and which records you want, and then include your name, address, and phone number. Some agencies may charge you a fee. They can only charge you the amount that it costs for them to get the records together. So they can't just say, hey, we're going to charge you $100,000 for these records. It has to be the actual copying cost or whatever it would cost for them to gather them. And you can seek a waiver if you find that you can demonstrate that it's of substantial public interest. Now, one of the challenges is you may get a document back that looks like this, where everything's been redacted except a very small amount. You may get, your request may be rejected. Now, one of the most important things is to make sure that you've made a full and complete request and that the request is narrow enough, because remember, it can be rejected as being too broad. You can also ask for clarification as to why your request has been rejected and see if there's a way for you to resubmit that in a way that will be more likely to be accepted. But there are some exemptions that you're going to be confronted with. Most notably, and I'm sure you can guess this, is national security. There are certainly going to be records that you will request that the government will not release to you and say that they would present the potential for harm to our national security if they were released. Internal agency rules, procedures will be exempted. Statutory exemptions exist. Anything that's considered to be a trade secret, memos that go within an agency, anything that is deemed to violate personal privacy. And then we have the circumstances of law enforcement records, that if they do these 6 things, which is interfere with a law enforcement proceeding, deprive someone of the right to a fair trial, unwarranted invasion of privacy, disclosing confidential sources, disclosing law enforcement techniques or procedures, and endangering the life of or physical safety of an individual. Now, there may be some information that you want that you will be denied, and here's some of the most common reasons why you will not have access to that information. One is the Privacy Act of 1974. Basically, this was a federal law that established this Code of Fair Information Practice, and it governs the way that we collect, maintain, use, and disseminate information that's personally identifiable about individuals. So, think in terms of the census and the Bureau of Labor Statistics. Some of that information is considered to be personal and private. The other one, of course, we have is FERPA, which is the Family Education Rights and Privacy Act. This is a law that governs the release of information about students, so things that are related to educational records can be restricted. Medical records often fall under HIPAA, which is the Health Insurance Portability and Accountability Act, and that is the reason why when you try to get information about people who are involved in some type of medical care, you try to get information from a hospital, they will cite HIPAA as a reason why they can't release that information. And then the last one that we sometimes encounter has to do with the Driver's Privacy Protection Act. And this was passed in 1994, and it basically deals with information that can be received using public driver's licenses databases. It was actually passed because opponents of abortion rights were using it to track down abortion providers and patients. And so the statute limits the disclosure of personal information without the express consent of the person to whom that information applies.